recorded.
At this time, I would like to turn the presentation over to Christina Rose, Deputy Director of the National Institute of Justice, the United States Department of Justice.
Thank you very much, and welcome everyone to this webinar. I feel very privileged to have been asked to participate, and I want to thank the good folks at the Office on Violence Against Women, our sister agency at the Department of Justice, and the National Center for Victims of Crime for inviting me to be part. Again, my name is Chris Rose, and I'm the Deputy Director at NIJ. And for those of you who don't know what NIJ is, we are the Research, Development, and Evaluation arm of the Department of Justice. We produce research results to help criminal justice practitioners and policymakers make good evidence-based decisions when they're faced with big problems that they have to solve. So today we're going to be talking about untested sexual assault kits. But before we get to that, I want to give you a brief overview of DNA backlogs in general, because I think it will help give context to the issue of untested sexual assault kits. So these headlines probably look familiar to all of you. Lately, it seems like absolutely no jurisdiction is immune from some kind of problem with DNA backlogs. Some of them number in the hundreds, some number in the thousands, and unfortunately, some are in the tens of thousands. So the question is, what is a backlog, and why do these backlogs exist? Well, first of all, there is no industry-wide definition of a backlog. Backlogs are dynamic in nature. They're changing all the time as evidence is tested and new evidence is coming in. Well, NIJ considers a crime lab backlog to be a case that has been waiting analysis for more than 30 days. But other jurisdictions may define this differently. Over the past few years, the demand for DNA testing has more than tripled, and there are many reasons for this. Number one, there's increased awareness of the use of DNA as a crime-solving tool. In addition, there's scientific evidence that shows that using DNA testing in property crimes leads to identifying offenders with long and possibly dangerous criminal histories. We know that DNA is being used more frequently in property crime cases, and DNA evidence is now being tested in cold cases to solve missing persons cases and in cases where there may be a question of guilt. And also, with the advances in DNA testing, scientists can get profiles from old and degraded samples of DNA. So we know that the capacity of crime labs has not been able to keep up with this great demand on their resources. Now, NIJ provides funding to crime labs to help them with DNA testing and also building capacity within their labs. That can mean training for DNA analysts or buying new equipment for them, or even helping them to hire new analysts to handle the new load. But even with the funds that we provide to them, the labs are still having trouble keeping up with the demand. So what it comes down to is they just don't have the resources. Now, in the news, the media often fails to make the distinction between two very different kinds of what are called backlogs. So when you see reference to unsubmitted or untested sexual assault kits, they're talking specifically about kits that have never been sent to a crime lab. The evidence is still in police custody. We at NIJ don't like to use the word backlog to talk about those kinds of cases. Only when evidence is sent to the crime lab and it's actually in the lab awaiting testing, that is what we consider a true backlog. So the NIJ research project that I'm going to be talking about in a few minutes focuses on the first kind, untested kits that are still in police custody. And I won't even call them backlogs. I'm going to call them untested kits in police custody. So, but before I get to that, I want to tell you about a recent NIJ study that was conducted on untested forensic evidence, so going beyond sexual assault. And when I talk about forensic evidence, I'm talking about DNA, I'm talking about fingerprints, I'm talking about firearms and tool marks. And in 2009, NIJ published the results of a survey of forensic evidence that had not been submitted to a crime lab, and the survey was conducted by the Research Triangle Institute. They surveyed more than 2,000 departments and received a response rate of nearly 73%, which is really good. And what they found was that between 2002 and 2007, police had not submitted evidence to a crime lab in 18% of unsolved sexual assaults, 14% of unsolved homicides, and 23% of property crimes. Now first, I want to make the very important point that there are many legitimate reasons why law enforcement may choose not to send forensic evidence to a crime lab. This can include a prosecutor may drop the charges, there may be a guilty plea, or sexual assault case, DNA testing may not be necessary for one reason or another. Maybe they had other very strong evidence in that case. If consent is an issue, sometimes evidence is not sent to the lab for testing. In this survey, when law enforcement officers were asked why they didn't send evidence to the lab, these were their responses. They didn't have a suspect. The case was solved without the evidence. The case was dismissed. The officer didn't feel the evidence was useful to the case. The prosecutor didn't request the testing. The suspect was identified but not charged. The lab couldn't provide results when they needed them, or they couldn't pay for the tests, or the backlog was too large and their lab was not accepting new cases. Now, some of these sound very counterintuitive. All I can report to you is this is what the survey told us that were the reasons that law enforcement did not submit to a lab. So really, what do these findings indicate? Perhaps more training is needed for police on how DNA is used or can be used as an investigative tool. Perhaps training on how best to prioritize cases. It raises a lot of questions. Now, nearly half of all law enforcement agencies do not have a computerized system for tracking forensic evidence. And this part of the study was very troubling because what we are finding in our other study on the untested sexual assault kits is that the lack of having some kind of system for tracking evidence and preserving evidence has been one of the factors that has led to these large accumulations of untested sexual assault kits. But anyway, I'm not sure if I already said this or not, but anyway, 3 out of 4 large departments have a system in place. With regard to evidence retention, jurisdictions varied significantly. 46% said they did have a policy in place, but 38% said they had no such policy, and 16% said they didn't even know if there was a policy or not. So basically, more than half had no policy or didn't even know whether they had a policy. So untested evidence is a big problem, and this is what led us to consider a research project on untested sexual assault kits. Because when it comes to untested sexual assault kits, there is no evidence out there to show that one method of solving that problem works better than another. There is no scientific evidence at this point. And when you consider what practices are being implemented around the country, it's really all over the place. Some jurisdictions are testing all kits, some are using a triage method, and some will not submit a kit if the victim has determined she doesn't want to go forward. She or he does not want to go forward to law enforcement. So, in thinking about the study, these are the questions that we considered as we thought more about the problem of untested sexual assault kits. How are decisions being made about whether or not to submit a kit to the crime lab? What unsubmitted cases would have benefited from the testing? If you choose to prioritize or triage cases, how should that be done? It's important to note that a sexual assault kit is only one part of the evidence that may need to be tested. There's a lot of focus on the kits, but there could be clothing, there could be bed sheets, fingerprints, fibers, etc. that should also be tested. The point being is that sexual assault evidence is often much more than just the kit. This is also a very important piece of the study that we're doing, and that is taking a victim-centered approach to the issue of untested sexual assault kits. It is critical to determine when and how you should communicate with victims in these cases. You never know how a victim will react when they're told, sometimes after many years, that their sexual assault case has been reopened. For example, some victims may not have told anyone about their assault, and being reminded of it could be very traumatic. And also, because of the time that has elapsed since the assault, some victims have moved on with their lives, and they very possibly may not have told their spouse, their children, their friends, other loved ones. So when do you notify a victim? When the case is opened, when a DNA profile is discovered, when there's a hit in CODIS? These are all the questions that we wanted to consider when we were taking up this particular study. So, Sexual Assault Kit Action Research Study. Let me tell you about the goals. We did not want to come up with short-term fixes by just throwing a ton of money at this problem. We wanted to get to the underlying reasons for why these large volumes of kits accumulate. And I have to say, we have received a lot of feedback from different jurisdictions where they have expressed that, why do you have to do a research project on this? Just use the money to test the kits. Move them out, and that's what's most important. And I could not agree more that testing the kits and getting justice for victims is very important, and we do have money dedicated to doing just that. But short-term fixes are not going to get us to the underlying reasons why these problems start in the first place. So we crafted this study so that we could identify evidence-based solutions that could be shared with other jurisdictions experiencing similar problems. And when we first got to thinking about this project, we knew how important the victim portion of this was going to be. So we approached the Office for Victims of Crime with a proposal for making this part of the study front and center, and they agreed to partner with us and provided $500,000 toward the total cost of the research project to develop and test victim notification protocols. So we are very grateful to OVC for that support. So I'd like to tell you a little bit about what is an action research project. Action research has very distinct features. The definition that I like to use is when researchers engage in an active partnership with practitioner agencies to solve a problem. So you've got a partnership between the researchers and the practitioners. Together they are identifying what the problem is, developing strategies to address the problem. The researchers are coming in, doing an independent evaluation of those strategies, and are able to figure out what works and what doesn't. And if something doesn't seem to be working, action research allows for what we call mid-course corrections, meaning you can go back and you can try to make it right and then continue to evaluate that new strategy. So NIJ in 2010, had an open competition, and we received 11 proposals. Each site had to have a backlog of 500 or more cases to ensure that we had enough data for the study, and believe me, they had way more than 500 cases. Each site was required to submit letters of commitment from all the partners, because in action research, collaboration among the partners is critical. Without it, you are not going to be successful. Our winners were Houston, Texas, and Wayne County, Michigan, which is also considered Detroit. And as you may know from the media and just doing a little bit of research, that both Houston and Detroit had been singled out for having very serious problems with untested sexual assault kits. So the study was divided into two phases. Phase 1 is an inventory of the sexual assault kits, interviews with key personnel, and the development of a research plan. And then phase 2 was identifying the strategies, the implementation, and the evaluation. So the sites: Houston, Texas, the lead is the Houston Police Department. The crime lab director there is Irma Rios, and the researchers are Bill Wells from Sam Houston State and Noel Bush Armanderas from the University of Texas, Austin. And in Wayne County, we have the lead, the Wayne County Prosecutor's Office, and that is Prosecutor Kim Worthy. And the researcher is, the lead researcher is Becky Campbell out of Michigan State University. So the timeline: the study was announced by Vice President Biden in a White House event in October of 2010. The awards were announced by Attorney General Holder in March of 2011. Phase 1 started in 2011 in April. Phase 2 began in October of 2011, and we expect results in 2013. And I can tell you that both Houston and Detroit have made substantial progress in moving these projects along. They have conducted interviews in Houston. They have already begun testing their sample protocols on victim notification. They've held focus groups with victims and have done interviews. In Detroit, they have already determined some of the reasons why they have found themselves in this situation. They have looked back at the culture and the staffing in the major criminal justice agencies over the past years, and have been able to determine what the underlying reasons are for why Detroit ended up with so many thousands. And I should probably tell you, in Detroit, we're looking at over 11,000 sexual assault kits, and in Houston, at the very beginning, there were about 16,000 sexual assault kits. So we're just looking at samples of those kits in each one of the jurisdictions. But based on the studies that we're doing, we will be able to generalize the findings somewhat through some randomized control trials. So anyway, I am finished with my portion of the presentation. I would be happy, after Ilsa presents, to answer any questions that you might have. I wanted to give you my email address. Dr. Kathy Browning is the manager of the Houston site here at NIJ, and Bethany Backus manages the project from NIJ for Wayne County, and you should feel free to contact any of us. So thank you so much for your attention, and I look forward to your questions.
Hi, Chris. Oh. Hi, it's Ilsa Connect with the National Center for Victims of Crime. Chris, you look like you have one question. Do you want to answer it right now? Oh, she might be muted. Okay, we'll go ahead. I want to welcome everybody also to the webinar, and I'm really thrilled that we have about almost 250 people signed in today. So it just goes to show how interested people are in this topic and how much I think sort of need there is out there for this information. My name is Ilsa Connect. I'm the Deputy Director of Public Policy for the National Center for Victims of Crime. And I actually want to say thank you to Chris for her efforts on this issue, because she's really been a champion on the problem of untested kits, and I think she's the driving force behind a lot of this work that's going on now. I want to thank OVW, of course, for sponsoring this webinar and our Training and Technical Assistance Project. We received a grant in 2001 through OVW to work to help communities that have sexual assault kit backlogs and that are working towards or hoping to test those kits. And our part of that is to help them with crafting an appropriate and sensitive response to victims in those cases. I want to just talk for a second about the National Center for Victims of Crime. Our mission is to forge a national commitment to help victims of crime rebuild their lives, and we work with all victims of crime. So we have people that are working on responding to youth victims of crime. We work on stalking. We work on elder victimization. We work on crime victims with disabilities. So we really do run the whole range of projects and training and technical assistance on all these various different victimization topics. We do our work through training and technical assistance. We also house the National Stalking Resource Center, so we provide training and technical assistance to communities, OVW grantees on stalking. We have a youth initiative which works to build the nation's capacity to support youth victims. And we also, as many of you probably have been to, we host conferences, trainings, and webinars such as this one. We also spend some time on Capitol Hill and in state legislatures working to secure funding and resources and protections and other rights for victims of crime. So our project we have with OVW, the goal is, as you can see here, to ensure that communities have the tools to create a victim-sensitive approach to sexual assault kit backlog reduction. This should say, and untested kits, actually, as Chris mentioned. We have, we have 5 objectives through this project. I'm going to go through them quickly because I have a lot to cover and we don't have too much more time. But we have 5 objectives. One is to create a series of webinars, and this is the first one, sort of introducing the project to the field. And they're all, of course, on developing victim-centered response. The next one that we'll be holding, we don't have a date yet, but it'll be the trauma response and the impact on victim notification and participation in the process of dealing with untested kits and how that, the trauma of sort of the coming to a victim 15 or 20 years later, how we should be taking that into account in the work that we're doing on notifying them and then including them in the case progress. We hope to do one on ensuring culturally informed responses. We're going to do some on prosecution and use of evidence in non-stranger cases. So I think we have a really interesting lineup, and this will be happening over the next 2 years. It's actually a 3-year project. And I'd also love it if you have ideas, send me ideas, or if you know a great speaker. We're looking for all different types of kind of different parts of this topic, this bigger topic that we can help people with. So if you have any ideas, please send them to me. We are also working to create an online resource library. We are collecting samples of policies and protocols on victim notification and really any kind of policies relating to working with victims in these cases. So we did put out a call to the field. We have collected quite a few of those, and those will be posted on our website in the near future. Our website is migrating to a new site, so we have a lot of information just kind of sitting and waiting to be posted, but that will be up there very soon. We have been looking at victims' rights statutes and other related legislation, which I'll talk about more in a minute, and any other resources that can help communities craft meaningful responses to victims in these cases. We already have a national DNA Resource Center. This is the current website. That'll change pretty soon. But right on that website, we have archived webinars, and we'll be including statutory comparisons of victims' rights, these sample policies and protocols, and other resources on that website. There we go. We're also providing technical assistance by email, phone, any other writing, you can write letters to us, on helping with notification procedures and policies, any other victim-related policies and practices that communities have when they're dealing with their untested kits. We'll be providing consultation to select communities and traveling to those sites as well. Objective number 5 was to hold a victim roundtable and to do interviews with victims. We actually did this first, so we thought that it made sense to have that sort of be the foundational aspect of the project and get information from survivors about what worked in the cases that they were involved in and what could be better. So we gathered 10 victims in February and brought them into DC, and we spent an entire day talking about notification, what different ways to help these victims find justice, for how they could be providing input into the cases, and what their ideas of justice, what their ideas are of justice. We will be providing a report on our website soon, and we'll also be holding a webinar specifically on notification, and we'll cover the findings from the roundtable at that time. So I think I went over this mostly already. We did a call to the field for written policies and protocols on notification. We also have made a lot of calls to cold case units regarding their process and their policies, and those will be on our website. But this is my my little, please send us yours if you have any that you haven't sent to us written on paper. That would be great. What we found is that a lot of communities had sort of an unwritten policy that they were, they all knew what they were doing, but nobody had really put it on paper. And so some of them were doing that after they talked to us. They said, well, we'll write it down. We'll send it to you. I want to talk a little bit about the victims' rights piece of this project. What we know communities are grappling with how to properly process this large numbers of kits, and that's definitely one issue. How do you deal with just testing them and deciding how to test them? The piece that, of course, we're interested in is how to competently and compassionately support the survivors in those cases. So our mission is to help those jurisdictions determine what rights these survivors may have. So we started looking, and we discovered that very few laws apply specifically to these cases. One that does apply is this California Sexual Assault Victims DNA Bill of Rights. And here I have some language here. I know that through some phone calls that I have had with folks in California that there's definitely a lot of work going on in terms of trying to have folks adhere to the law and to make the law meaningful. But I just wanted to show you some of the language here. We have, upon request of a sexual assault victim, the law enforcement agency investigating may inform the victim of the status of her case. And then we have this subject to the commitment of sufficient resources. And all of you in the states know when you put that language in, it's kind of a loophole big enough to drive a truck through. So, but I do think from my conversations with some folks in California that there is some work around trying to make this meaningful, and it would be great. I wanted to just share it with people so that people knew this was really the only statute that we found that was specifically geared towards these cases. Okay, so we started looking also at other victims' rights laws that may be interpreted to apply to these cases. And I have to say the disclaimer here is, of course, it's not legal advice. We just started looking at what the language is in these statutes, at some of the laws that are already on the books for victims' rights. So those examples will be on our DNA Resource Center when the address change, and here I have the new address here for you. I want to just go over a few of the things that we looked at. Well, that's what our nice new website's going to look like. So there's a screenshot. So we started looking at victims' constitutional right to fairness, dignity, and respect. We also looked at victims' bills of rights, and specifically we're looking at the ones that apply before charging, so that a suspect didn't have to be charged. Because we know what's going on. Why I call these cases in the mushy middle is because often the case is moving forward. There's an identified victim, but a suspect hasn't been, in many cases, identified or charged. And so some of those cases that are on the books, in fact, quite a few of them don't actually kick in at that point. So we wanted to look at the ones that were either kind of silent on when the law applies, or that were clearly allowing the law to apply before a suspect is charged. This is just some language that showed actually that it was a little less specific about when the law would start to, or the rights in Rhode Island would apply in these cases. In terms of fairness, dignity, and respect, I just wanted to say that 23 states, victims' rights constitutional amendments, and many state laws have some type of language that provides a victim should be treated with fairness, dignity, and respect throughout phases of the criminal justice process. So when we started to look at this, we thought, this right, by the way, is very important, of course, as many of you know, to sexual assault survivors who have survived an especially brutal crime. And many of those victims have waited years and years for justice, and they have lost faith in the criminal justice system. And so to me, I felt that this right was something that we all should really be looking at, and how can this be used in these cases? So many of them read the way this Texas law does or similar to it, that the crime victim has this right to be treated with fairness and with respect for the victim's dignity and privacy throughout the criminal justice process. So in my mind, that seemed like, well, there's no language here that says that the right would apply only when a suspect is charged. So to me, I thought, well, yeah, this seems like victims in these cases should be treated this way and have this right. One of the big things we looked at is notification. I think many of you probably know, and Chris talked about, these cases are 10, 15, 20 years old. And I know, having worked with some folks who have made these notifications, and some that were doing this work really early on, didn't necessarily know what to expect or know how victims were going to react to being notified. And so I think people have learned a lot, that there's such a range of responses. But victims really rate being kept informed of various developments of the case as more important than the actual outcome. So how that happens is very, very important. And we looked at notification because, of course, that's the first step of real interaction with victims in these old cases, and how it's done and who does it and when it's done is really, it's important to get the right mix for each individual victim. Of course, I call this right the threshold right, because if you don't know your rights, you can't know your rights if you are not informed of your right. If you are not informed of your rights, you don't know you have rights. Sorry, I wasn't saying that very well. The notification includes a notice of available resources, compensation, a notice of events and proceedings. And again, few states except California really explicitly give victims the right to be informed when their kit is moving forward. Let's see, Oregon. I wanted to just mention that this is just one example of a notice of rights, and the statute doesn't require an arrest to be made for the victim to be afforded this right. We also looked at the right to be heard. It's a very crucial means by which victims play a proactive role in the criminal justice system. So many times the right to be heard, does apply and starts to kind of kick in when a suspect is identified or charged. So we started to look at other ways or other laws that maybe gave some victims a right to be heard in cases that weren't able to go forward. We were looking at cases that were past the statute of limitations, and we were looking at giving a victim impact statement at other trials involving the same perpetrator, or in parole proceedings. So we started pulling some of those statutes, and those will also be on our website. Here's one example, Alaska. Any person, group, or agency may submit written information to the board for consideration. And we'll have more of those on our website as well. We also started looking at the right to timely disposition. A number of states have passed these laws giving victims a right to a timely disposition of their case. And when I started looking at this, I thought, I'm really interested in this law, because, of course, the victims in these cases have not had any kind of timely disposition. And I felt like, they really deserve this right tenfold. So we started looking at the states that have this type of right, and these will post it on our website. Right to information about case status. This is another example of a right to be kind of kept informed. A number of states give victims the right to notice of status of the investigation of their case. And I started to think that by exercising this right, victims may be able to inquire about the status of their kit. We also looked at victim compensation. And because we know that being contacted 10 or 15 years later after an assault, that your case is or maybe moving forward, it can be very traumatic to victims. We looked into whether or not by state law could victims apply for compensation in these old cases. And what we found is that overall applications for compensation generally have to be made within 1 year. but many states have what they call a good cause exception to the late filing of claims. And some of those break down more about what that is, but some of them just say basically that the good cause can be determined by the compensation board. What we decided to do then is to conduct a survey of compensation administrators. And what we found is that 78% said they would be very likely to consider a claim for compensation in cases in which, a sexual assault kit was tested and the filing deadline had passed. One state has a cold case policy specifically allowing for compensation for these victims, and we got a lot of actually responses that had said sort of like, oh well, we haven't had a case like that, but and we haven't really thought about it, but now we're thinking about it. So I thought that was kind of interesting. So the other related policy issues that we'll be looking at and having, again, examples on our website, we'll be looking at John Doe warrants, when a indictment can be made against a DNA profile, when a suspect or a perpetrator is identified through a DNA profile but is not yet identified by name. We'll be looking at the statute of limitations in different states. We'll be looking at states that have their sort of test every kit laws and related laws to that sort of mandate. We'll be looking at mandatory turnaround times, arrestee collection from all arrestees. We'll be looking at those laws. And laws similar to this Texas law that allows a cold hit, which is a match on a DNA database, that information to be put on somebody's criminal record. So even if that person cannot be charged or prosecuted for that crime, maybe the statute of limitations has expired, a law like what Texas has would allow that information to be on that person's criminal record. So we'll be pulling information on all of these different policy issues. And mostly, one of our big sort of goals of this project is to really look at creative ways to help victims find justice in these cases. Many people I have talked to, survivors, have been involved in cases that in which the statute of limitations had expired and the case was not able to be prosecuted. And so it just got us really thinking about what does justice really mean in these cases. And we spent a lot of time talking about that at our focus group, and we came up with a lot of interesting and helpful information from those survivors. So we'll be, again, posting some summary about that on our website and doing a more involved webinar about our findings from the focus group in the near future. This was a quote from one of the survivors, that the process is just as important as the outcome. That how they are treated during this process really is, most of these survivors said, was the most important part to them. Of course, they wanted, justice. They wanted to see the perpetrator, have to face some sort of consequence, but it was very important to them how they were afforded their rights and the things that, the support that they got during that process. I wanted to just also mention that we, as part of our larger DNA education project, we've created these pamphlets that are available for download on our website. One is specifically for victims, DNA and crime victims, what victims need to know. It's a bunch of basically Q&A, frequently asked questions that we have received from survivors and tried to sort of succinctly answer specifically for survivors. We have one that's for victim assistance professionals. And then we have one for more geared towards law enforcement about notifying crime victims in cold cases where there's a hit on the DNA database. This is my thank you to the Office on Violence Against Women for our grant. And I think that's actually it. This is my contact information. And we got a few questions. I'm not sure, Chris, do you, looks like some of them are NIJ questions. You want to take a couple of those?
Sure, I'd be happy to.
Okay, great.
Yeah, no, great questions have been coming my way. And there's one that says, does NIJ have any talking points for states to diffuse the media's hyperbole of untested kits? And, we got so many questions at NIJ about untested kits, and people had so much misinformation about it that we actually wrote 2 documents. and they are on the NIJ website, nij.gov, and one is called Making Sense of DNA Backlogs by a gentleman by the name of Mark Nelson, who is a forensic scientist here in our office. And the other one is called The Road Ahead, Unanalyzed Evidence in Sexual Assault Cases. This is a report that really goes in depth around the issue of untested sexual assault kits and provides wonderful fact-based information about what the problem really is and what it isn't. So both of those publications were created specifically to respond to the myths and the misunderstandings around the issue of backlogs and untested kits. So I recommend those highly. There was also a question about, it says, if the Houston Police Department Crime Lab is a site, wouldn't their kits be considered backlog versus untested? And that's a terrific question. Each one of the sites, both Houston and Detroit, they are made up of a partnership. For example, in Houston, the number of partners that they have is huge. They have the Crime Lab and Forensic Services, Adult and Juvenile Sex Crime Investigative Units, the Harris County District Attorney's Office, the Houston Area Women's Center, the Sexual Assault Nurse Examiners from the hospital in that area, as well as the research partners at UT Austin and Sam Houston. The only reason that Houston PD is the site is because of that partnership. It was determined that Houston would be the one to submit the application, as they were a state agency and were eligible to do so. So Houston is the recipient of the kits that are being tested that are coming out of police custody. But we are not dealing with any of the kits that are already at the lab awaiting to be tested. So I hope that clears that up somewhat. Ilsa, I'm going to throw it back to you for a moment.
Okay. There were a couple questions about sort of information, how to get this information later. I certainly can send people the PowerPoints if they want to email me, but I will mention that the webinar was recorded. I'm not exactly sure how that link will be provided, but I'm guessing we'll be putting it on our website. One thing that we are going to do is send out an email to all of you that have participated today to evaluate the webinar, and that will be a SurveyMonkey evaluation. So when we send that, hopefully we'll have the link and we can send it to you. But I'm assuming that we'll be posting that on our website, and I'll probably have to get approval from Chris, but we usually also put our PowerPoints up there sort of in a PDF version.
That should be no problem.
Okay, great. I don't see other questions. Do you? No. I don't think, did you? No, I think that's it. I think I don't see any others unless you do, Chris.
Let me see. Did you go down to the bottom there?
Yeah.
About cold case policies?
Yeah, actually somebody did ask me which state has the cold case policy, and I think she was referring to the compensation policy I mentioned, but when we did our survey of compensation administrators, we promised them total confidentiality. So I don't know, I don't feel that I can release that unless I go back to them and ask them, is that okay if I tell people who it is? So I don't actually even know off the top of my head who that is, but it's actually on my to-do list to find out. But so I'm sorry, I can't release that at this time. But
I see another question for me about the backlog in Houston started at 16K. How did it end up being reported at 6,600? I have to tell you, there are a lot of numbers being thrown around, and the 6,600, I'm just looking through some information that I have here, because what NIJ is doing is just looking at a sample from the 16K, but I know that as they were going through and doing the audit, they actually determined that several of the kits had actually been tested and had ended up in this big pile of kits that they didn't know what they were. So even though that we're calling it a backlog, and we shouldn't, but the untested kits started at 16,000, and it has gone down as they have taken the time to do the audits of the kits, and they're finding out that some actually had been tested, some there was a guilty plea and it didn't need to be tested, or it had been adjudicated in some way or another. So I can actually hook you up with some folks at Houston that are doing the research that can give you more information about that. So if you want to email me offline, I would be more than happy to get you a more definitive answer on that.
There's a question here that I actually really love talking about, and Chris, you probably have some thoughts on this too. The question is, what is the goal of submitting untested kits that cannot move forward for prosecution? And what I learned from the roundtable that we did with the survivors, and just through other, somebody needs to mute, sorry, I'm having a little feedback, but from other sort of conversations with people or victims that have been involved in these cases, there's so many reasons, actually. I mean, one really from that perspective is that victims, there are lots of answers that they haven't had all these years, and they often don't even know who the perpetrator is. In one case, I talked to a woman who the kit was tested, I think it was 15 years later, and found out that the perpetrator was a friend of her husband's. And all these years had been having an interaction with this person, and keeping her husband had been friends with him. Or it could be the person who lives down the street from you, or there's just a lot of reason for victims to know who the perpetrator is, even if the court system can't punish them. There's sort of a need for answers and a need for personal protection as well about that person, from that person, I should say. And I think, we've seen some of these cases connect to other cases. We see serial offenders, and even if those some of those cases, we link 6 cases sometimes, and even if 5 of them can't be prosecuted, we still can see that this person was a serial offender. It gives information to criminal justice officials to help them kind of investigate and prosecute those cases. So, and again, in some of these other cases, I think there were probably almost, maybe close to half of the survivors in our round table had cases that couldn't be prosecuted because they were past the statute of limitations, and they had other ways that they were able to feel that they received a sense of justice in those cases, including one that very recently gave an impact statement at the trial, a trial of the offender in another case. But they knew that was her offender because they tested her kit, even though they knew it was past the statute of limitations. So when you look at it from a victim perspective, it's not only about obtaining kind of prosecution through the court system. It's another kind of broader sense of justice that they are looking for. So, Chris, I don't know if you have anything to add to that.
No, I thought you covered that very nicely. I mean,
okay.
I think that example you used of the survivor that was able to give a victim impact statement, even though her case had been past the statute of limitations, I mean, that was just huge. That was huge for her, and it showed you the value of testing cases beyond the statute of limitations, if anything, just to give these survivors some of the answers that they've been seeking for so long.
Right. And we have 4 more minutes, I guess. Well, sort of 4 minutes. There is one question I don't have a great answer to. This might be a better question for you about the lack of adequate, I just lost it, information management systems to track the evidence. I'm missing the second part of the question, but do you see that one, Chris?
Yeah, I did. It's from my dear friend Jim Markey, and he's asking to comment on the lack of adequate information systems to track the evidence, and is FIDEX still a viable solution? FIDEX is a system that NIJ funded and tested in both Phoenix, Arizona, and I believe in Boston, Massachusetts. And it's a system that connects disparate information systems so that different parts of the criminal justice system can talk to each other. And my understanding is that FIDEX is still a viable solution, and for those that are listening in on the call, if they are interested in learning more about FIDEX, and it's forensic information data exchange, something like that. But I can certainly put you in touch with folks that can talk to you about this, and I can even recommend Jim Markey as somebody that people can talk to more, because he worked on the pilot while he was still at the Phoenix Police Department.
Great. Oh, sorry, I muted myself and I couldn't get unmuted. Let's see. We might have time. I don't think I see any other ones. There was a question about certificates. It's a sort of a housekeeping thing. If you email me, I can send you a certificate for participating in the webinar. I think that kind of wraps it up. If people want to email us their questions, if we miss them, we'd certainly be happy to answer them or send you to someone who might know better than we do. I want to thank everybody for signing on and participating, and feel free to contact me if you have any questions or anything that I can help you with regarding working with victims in these cases.
Yeah, and I want to echo Ilsa's sentiments. I also want to let you know that we did have a panel at the NIJ conference last week that featured the researchers from the Houston and Detroit sites, as well as a discussant, Debbie Kane from Michigan. And that was a wonderful discussion, and I can see if I can provide you the PowerPoints from those presentations, because it'll give you a much better sense of what's going on in both of those sites. And I'm also checking to see if it was recorded in any way.